as a question. The aggravating factor is stated as a question, and in the issue 1 on the verdict sheet, it's stated as a declarative statement. So that there is a difference there. I've not gotten far enough to look at issue 3. And actually, the writing by the foreperson actually points us to, on issue 3, to page 16 of the instructions, paragraph 1, which you don't have the same printout that I do. And it is essentially is the final mandate for issue 3 is what they're pointing out. The language is different. The final mandate in the instruction says, if you unanimously find beyond a reasonable doubt that the mitigating circumstances found are circumstance, parentheses, as found, are insufficient to outweigh the aggravating circumstance found by you, you would answer issue 3 yes. So the language is slightly different, but not in any material sense. And then on issue 4, page 16, the last paragraph. I'm not even seeing a statement on page 16, last paragraph that I guess in the last paragraph on page 16 it says, therefore it is not enough for the state to prove from the evidence beyond a reasonable doubt the existence of an aggravating circumstance. It must also prove beyond a reasonable doubt that such aggravating circumstance is sufficiently substantial to call for the death penalty. And before you may answer issue 4 yes, you must agree unanimously that it is. I guess the words call for the imposition of the death penalty as opposed to call for the death penalty. I don't see any material difference between the language. I think the instruction I would give is that they should go by the verdict sheet and use that. That if they believe there's a material difference that they are caught up in, that if they could clarify that in a note, but if it's just simply a matter of semantics, then perhaps they should, that they would be guided, that their ultimate decision would be based on what is stated in the verdict form. But if they need further guidance on any difference that they see, they should specify it more specifically. Would that seem like an appropriate answer on that part?
Yes, sir.
All right. Now let's talk about the question of unanimity. My sense at this stage is to instruct them that they should effect, not an Allen charge because they've not given any indication that they are unable to reach a unanimous verdict, but simply tell them that they should use their best efforts to reach unanimous verdict with respect to each of these issues 1, 3, and 4.
And that was just my only question. They asked about 1, 3, and 4, not 2.
That is correct. What does the defense have to say about that?
For the record, we would ask that the instruction, proposed unanimous instruction, that we submit it. And so the unanimity of this instruction conference be given. I don't wish to go further.
All right. Does the state have any further thoughts on this?
Nothing.
We agreed with your proposal at this point, Your Honor.
I think the language of the Allen charge is probably a good summary of, basically the Allen charge, which is pattern instruction 101.40, is you are reminded it's, or just simply I would say in response to this, I would tell you that it's your duty to do whatever you can to reach unanimous verdicts as to issues 1, 3, and 4. You should reason the matter over together as reasonable men and women in an effort to reconcile your differences if you can without the surrender of conscientious convictions. But no juror should surrender an honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. That's the Allen charge. They've not indicated a deadlock of any sort, but I think rather than simply saying you need to reach a unanimous verdict, I think that that's probably appropriate language at this stage. All right. State wish to be heard.
We have just one. I don't know. The Allen charge is a very specific charge for a deadlock issue, and I don't get the sense from that question that that's where they are, that they're just asking for some clarifying. Do we have to be unanimous on 1, 3, and 4? And I almost think the best answer to that is just yes at this point. That would kind of be my thought, but. It's not.
I think the Allen charge, it's not that, I think the Allen charge doesn't only have to be if they're saying that deadlocked. I think given the question and the circumstances, it seems to be appropriate right now to say that response to it.
I'll give the Allen charge. If they do become deadlocked, they indicate that I actually expand it a little bit. But we'll talk about that if we come to that. But I think that this language is certainly sufficient to guide them at this stage. All right, so that's what we'll do then. If you'll bring,
Just for clarity, Your Honor, it's 101.40 and you're removing the first line.
which says your foreperson has
Right.
informed me you've been unable to agree upon a verdict.
Yes, sir.
Yes, I'm just going to say that with respect to your question, it is your duty to attempt to reach a unanimous verdict as to issues 1, 3, and 4, and then continue with the, you should reason the matter over, et cetera. All right, let's bring jurors. All right, ladies and gentlemen, you have sent out a couple of questions, and let me read them and take them up one at a time. So the first question is, for each issue 1, 3, and 4, are we required to come to either a unanimous yes or a unanimous no? And the answer to that is that it is your duty to do whatever you can to reach a unanimous verdict as to issues 1, 3, and 4. You should reason the matter over together as reasonable men and women in an effort to reconcile your differences, if you can, without the surrender of conscientious convictions. No juror should surrender an honest conviction as to the weight or effect of the evidence solely because of the opinion of his or her fellow jurors or for the mere purpose of returning a verdict. But yes, you should use your best efforts to reach unanimous verdicts as to issues 1, 3, and 4. The next question talks about the phrasings of questions on the issues and recommendation form sheet. You note, I believe, that they are consistent, and I'm assuming that's between the two issue and recommendation form sheets, namely the one for Anglia Taylor and the one for Sylvester Taylor, while the phrasing in the instructions is not, and you point me to issue 1 on page 4, paragraph 2, issue 3, page 16, paragraph 1, and issue 4, page 16, last paragraph. I've examined all of those, and yes, there are semantic differences between the wording of what the instructions say you must find and then the wording that is on the verdict sheet. What I'll say is the language on the verdict sheet is to control. That is what you must answer ultimately in your deliberations. I have not detected a material difference between anything that is in the instructions and what is on the issue and recommendation form. If you believe there is a material difference and need clarification as to specific phraseology, bring that to my attention specifically. But you should not concern yourself that, for example, issue 1 in the instructions is stated more as a question, and the issue on the issue and recommendation form is stated as a declarative statement. So unless you see a material difference between the instructions and the issue and recommendation form, you are to be guided by the issue and recommendation form for your ultimate responses to those issues. But again, if you see a material difference or anything you need clarification on, if you'll just specifically say, is there a difference between this and that, and I'll be glad to address that specifically. All right. Thank you. We'll ask you return to your deliberations. Any objection to the dialogue just had with the jurors?
No, sir.
All right, we'll be at ease.
Your Honor, just
Yes.
when this jury, when and if this jury does return a verdict today, just a couple of housekeeping matters. One, the state does intend to offer two witnesses or two family members for victim impact statements.
That'll be fine.
They're here and have been. The other thing, in terms of releasing the jury, obviously you do handle that how you want to handle it, but I know from last year that the jury was interested in staying around for victim impact statements, and so if you feel comfortable inviting them to stay, I would ask that you do that. I'd also say that I know Sylvester Jr. has expressed interest in thanking them as well, and so I'd ask that. We also always like to hear from jurors afterwards. Mr. Lively and I have put our business cards on the window sill kind of outside of your office, so either I can tell them they're there or Your Honor can tell them they're there, and obviously invite them to speak with us after the trial as well in whichever manner you feel is appropriate. But those are just a couple of general thoughts I had on how to handle it if a verdict comes back today.
That would be fine. Anything, Mr. Brown, Ms. Hamburger, on housekeeping matters?
Just a couple of things. I guess we would like to have the same opportunity, although I don't know if I have my business card with me. But maybe we can some way get notes about that too. I would ask, and this is actually not a concern particularly with this family, but I do know that sometimes in the past there have been victim impact statements that have directed it towards defendants, and I think it's more appropriate that it be directed to the court when people are speaking.
We've spoken with the Taylor family about that, and I don't.
Okay.
I don't think that's a concern in this case. I think they more want to represent who they're. Ms. Sharon Johnson is going to speak on behalf of Anglia, and Mark Tonio is going to speak on behalf of his father. We talked about it a little bit, and I don't think that's a concern in this case.
Okay.
Right.
All right.
Okay.
I didn't think it was a concern in this case. I just brought it sort of as a general conversation.
All right, thank you. All right, then we'll be at ease.
If there's any